Hi, everybody. Welcome to another episode of Pretty Lies and Alibis. I'm GiGi flying solo. Fruit Loop's got a doctor's appointment later this week, so we're gonna see what's going on with her. Hopefully, she'll be back soon. In the meantime, wasn't planning on doing an episode. It's been a crazy weekend at Crime Con, fun, exhausting. Haven't slept since Sunday. Let's see, no, Saturday night. I woke up yesterday morning. Haven't been to sleep since, and then here we go. Big news in the Lori Vallow case. They filed their intent to seek the death penalty against Lori. We're going to get into all that. But first, we want to give a shout out to one of our sponsors, Two Cool T-Shirt Quilts. You can go to twocooltshirtquilts.com/pretty lies and alibis. Check them out. They'll know we sent you and we appreciate their support. Also, big thank you to Eunice and Debbie, both for the PayPal donations. We appreciate your support as well. So, I'm going to do a big recap episode of CrimeCon probably tomorrow. I really want to get all my thoughts down and make sure I don't miss anything at all. But I can just say out of the gate, everybody that we all know from this case, whether it be Kay and Larry or Hidden True Crime, Lori Hellis, Nate Eaton, everybody. I had the privilege of meeting this awesome group of people this weekend and share some time with them and talk about all things true crime and then just life. And I have to say, as we all assume, everybody's just amazing. Can't wait to tell you all about it. That's definitely for another time because we got Vallow news to talk about. But if you don't follow us on social media, I had posted this weekend, but Nate Eaton was there and gave a couple of talks and couple of little things that were new. So one thing that really piqued my interest was somebody close to the investigation or the case told him we don't know the half of it. And we've always said when these facts come out, it's going to blow our mind. It's going to break our hearts a million times over. But he did say that. Also, some insight into Chad. Nate said that as far as he has heard, Chad has a laptop in his cell and he can't connect to the internet. So he's not tweeting and Facebooking. But apparently, pretty much all he does is go through all of the evidence in this case. What else do you do? You're sitting in jail. But anyways, the other thing, and this doesn't surprise me because me and Fruit Loop have said this for months, that somebody has got to flip on somebody. It seems like maybe now Chad has done that. It's really obvious, maybe from the hearings we've had where Pryor says Miss Vallow, Archibald says she prefers to be called Miss Daybell. You can read the tea leaves, but apparently Lori is still committed to Chad, and as far as we know, committed to their whole belief system where the end of the world should have come, what, like almost 2 years ago, but didn't. So, okay, let's get into these filings today. So, as we said in the beginning, the state filed their intent to seek the death penalty against Lori. And so it's repetitive. So I just kind of condensed it down. It says the state of Idaho, by and through the Fremont County Prosecutor's Office, hereby puts the court and the defendant on notice pursuant to Idaho Code 18-400A that the state will seek the death penalty against Lori Noreen Vallow, aka Lori Noreen Daybell, in the event of the defendant's conviction for any of the counts of first degree murder and or any of the counts of conspiracy to commit first degree murder as charged in the indictment. So they go down for every person, but essentially it says the murders of Tylee, JJ, and Tammy were done for remuneration, which means done for money. And the definition of that is money paid for a work or service. And it also says the murders of JJ, Tylee, and Tammy were especially heinous, atrocious, or cruel, manifesting exceptional depravity. All those things we know to be true. And just again, a testament to going back to what Nate Eaton said at CrimeCon. We don't know the half of it. And unfortunately, that's going to be those devastating details that we will hear at trial. So there's been a filing about moving her trial date up. We're going to get to that in just a second. But it says, by the murders or circumstances surrounding their commission, the defendant exhibited utter disregard for human life. The defendant, by her conduct, whether such conduct was before, during, or after the commission of the murders at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. And they're right. People with those kind of beliefs and the actions they've took, yeah, they don't need to be walking among us ever again. So now here's the thing. We know Lori just had a trial date scheduled for October 11th of this year, very soon, considering a few weeks ago, we didn't even know if she was competent. So we know she is. They set a trial date. It says they had a 13-page filing in their argument as to why we should move Lori to January to join Chad. So I've just picked out some of the best parts that's not repetitive. It says, while this court recently entered an order setting a trial in the above captioned matter to begin on October 11th, 2022, this court has repeatedly found and held that these cases are one for trial. It is proper to continue the October trial setting for both defendants' cases and restore the prior trial date scheduled to commence on January 9th, 2023. If both cases are not set for trial at the same time, it will result in an improper severance. It goes through how they came to get the charges through the grand jury for both Chad and Lori for the charges they currently have. And then they go through recounting how Mark Means raised the issue of competency. She was hospitalized. That was extended in, I believe, September of last year. And then now she's competent. So it goes on to say, and following its review of the psychological assessment, determined that the defendant was incompetent to stand trial on June 8th of 2021. On June 9th of 2021, this court entered an order staying case in the above entitled manner, pursuant to finding of incompetence and commitment of defendant Vallow Daybell to the state hospital. On September 22nd, 2021, an order for extended commitment was entered following a progress report from the state hospital on restoration efforts. On April 11th, 2022, this court entered an order finding the defendant Vallow Daybell fit to proceed and lifting the previously entered stay. On April 19th, 2022, defendant Vallow Daybell was arraigned and pursuant to her request for a speedy trial setting within statutory speedy trial limits, her case, along with her co-defendant Chad Daybell, was set for trial commencing October 11th of 2022. The court must order that a prosecution or indictment be dismissed if not brought to trial within 6 months, unless good cause to the contrary is shown. The state bears the burden of demonstrating that good cause exists for delay of a trial beyond the 6-month statutory prescribed time period. So it goes on to say the court should find good cause to continue the trial date as the reason for the delay arises to the level of a legal excuse and the length of the delay is short in relation to the complexity of the case. So they've done their homework and they make some good arguments in here. So let's dive in. It says defendant Vallow Daybell's case is uniquely positioned as good cause arguments are being made shortly after arraignment and months before issues relating to witness availability, evidence testing, notice of affirmative or mental illness defenses, full exchange of discovery or argument of all pretrial motions have occurred. The state asserts this fact in itself constitutes good cause. As noted above, great weight should be attached to the time needed to address full exchange of discovery, litigation of all pretrial motions, and collect witnesses. This is even more true in a case of this complexity with massive discovery and with the added complication of arranging trial logistics in a different venue. Further, co-counsel for Vallow Daybell has only recently been appointed, and the time to digest the status of the case, prior pretrial motions filed by former defense counsel, and review discovery have been limited. Because as you know, everything was off. They couldn't have any hearings about things that Mark Means had filed, even though Archibald and I think it's Thomas. I'm sorry, I haven't learned his name, have joined this case. Both, by the way, are death penalty certified. And so when death is on the table, it's usually two death penalty certified attorneys. They'll probably bring on like a mitigation specialist who will argue maybe mental illness, even though there's no insanity defense in Idaho. They can argue mental illness in the mitigation phase in considering life or death. So it's going to be interesting to see who they bring on. It says the indictment in this matter alleges 9 counts, with 3 counts of conspiracy and overt acts attributed to both defendants. This is a complex case involving extensive evidence and multiple witnesses. Preparation of the grand jury transcript alone took approximately 3 months. That's a lot. I would love to read that, but, you got laws and stuff. The state has been diligent in reviewing evidence and disclosing evidence to the defense, but there are still items that remain outstanding that have yet to be produced in discovery or are awaiting argument and rulings from the court in relation to consumption of DNA samples. If you remember, prior had a big problem with the fact that the DNA tests that they were going to perform on things that are relevant to the murders, it was going to consume the entire sample. So it left nothing for the defense to have independently tested and have their own expert come in and weigh in. So the complexity of the case weighs in favor of finding good cause for a continuance of the trial date beyond the 6-month statutory guideline. The brief continuance of defendant Vallow Daybell's trial also allows for properly joined co-defendants to proceed to trial in an efficient manner without allowing a type of improper backdoor severance of the cases to occur. This court has entered a decision denying defendant Chad Daybell's request for severance. And in that decision, this court found that joinder of defendants gosh, I'm tired, y'all. Daybell and Vallow Daybell was proper and that the defense had not met its burden to demonstrate prejudice requiring a severance. This court further determined that a joint trial would serve the interests of justice by providing for judicial economy, procedural efficiency, and avoid possible inconsistent verdicts. The court's rationale is valid and would be undermined by allowing one joined co-defendant to assert speedy trial as a method of obtaining improper severance early on in the case. A scenario could develop where defendant Vallow Daybell's current assertion of speedy trial results improperly in a premature severance, and then later basis for continuance is discovered as the case progresses, and defendant Vallow Daybell's waiver of speedy trial is then entered. At such point, would the trial dates be rejoined? Would such a scenario result in further delays? The court's determination of good cause to continue defendant Vallow Daybell's trial date for a short period, as proposed by the state, ensures the cases remain properly joined and avoids further complications in the future. And that's a really good argument, I thought, in that they have not had time to sit down and go through what Mark Means has put together for a defense and to decide, are we keeping that? Are we going this way? Are we going that way? It could be different now if they know that Chad has rolled on her. We don't know rolled, but clearly it's every man for himself. And um, Chad's living in the real world, as it was said now. So he understands his literal life is on the line. Now we know that he took lives. So, but things get real and things have gotten really real in this case lately. It's like we say the long road to justice. Well, we've been on the Audubon lately, guys. It's been like one thing after another. And we knew when she was competent that would start happening. And we're seeing it. So it goes on to say, furthermore, this court has granted a change of venue that was brought and argued in defendant Chad Daybell's case. As defendant Vallow Daybell's case was stayed at the time, no argument was made on her behalf as to the change of venue. However, defense counsel for defendant Vallow Daybell stated on the record at the April 19th, 22 hearing on the state's motion for the court to allow additional evidence and follow Idaho Code 19-1816 by transporting a jury that defendant Vallow Daybell agreed to the venue change and with the court's decision to hold the trial in Ada County. This court has determined that in the interest of ensuring a fair trial, a change of venue to Ada County is necessary. This court has further determined that the co-defendants are properly joined for trial. So the foregoing arguments in favor of finding good cause to continue defendant Vallow Daybell's trial date have been in relation to the reason for the delay and a calculation of the length of delay from her arraignment and entry of not guilty pleas on April 19th, 2022 to the January 9th, 2023 trial. Idaho Code 19-3501 and a constitutional analysis of speedy trial include consideration of the date from which a complaint or information is filed, an indictment found, or an arrest made. This court has held that the Idaho speedy trial constitutional protection is not necessarily identical to that right guaranteed in the Constitution of the United States and comes into play no later than the time at which the complaint is filed. They used a case called State versus Holtzlander, 102 Idaho 306 310 from 1981. If you want to go read that, I may do it when I have a little more sleep under my belt. But it says in defendant Vallow Daybell's case, an indictment was found and filed with the court on May 25th, 2021. An arrest warrant was served on that same date. Defendant Vallow Daybell had a first appearance on May 26th of 2021. However, no further actions were taken because the court was aware of the pending competency order. As noted previously, a stay was entered and remained in effect until April 11th of 2022. The need for restoration efforts and the length required for that is directly attributable to the actions of the defendant. The defendant's actions or in any pre-arraignment delay is therefore not chargeable in the state. The defendant's assertion of his or her right to a speedy trial is entitled to strong evidentiary weight in determining whether the defendant is being deprived of the right. And that's from Ridson at 250. That's a case. Defendant Vallow Daybell has clearly and affirmatively asserted her speedy trial rights as of the date of her arraignment. The bulk of the delay in her case thus far has occurred from indictment and her arrest and prior to this assertion of speedy trial. So in a case called the State versus McNew, 131 Idaho 268, this is a 1998 case, the court found that a delay in the trial setting due to the defendant's request to undergo a psychological examination was attributed to the defendant and weighed against a later assertion of speedy trial rights. So essentially what they're going to say is that they shouldn't have to sever these trials or separate these dates because she was incompetent and may not be ready. So, and I think they're right. I don't think this ever would have went in October anyway. I think it would have been delayed at some point. But we've heard Lori wants the joint trial. That's what I heard this weekend. It is clear that the delay in resetting the trial for a date prior to October 9th in 1995 regarding this case was entirely due to McNew's refusal to cooperate in the preparation of his psychological examination and that the state did nothing to cause or facilitate further delay of the trial. The period of delay is on McNew and it will not be weighed against the state. And the court also determined that the failure to assert speedy trial until well after the 6-month time period had expired, combined with the defendant's request for continuances and the delay in addressing the mental health concerns, indicated that McNew did not necessarily want a speedy trial. So we've said, does she really want this? Probably not. There was some strategy in that. This court should also consider the time taken to address Vallow Daybell's mental health concerns and the resulting delay to her case in assessing the weight to be given to the assertion of her speedy trial rights at this time. So the final Barker factor to address is the prejudice to the defendant that arises from any post-arrest delay. And it says prejudice is to be assessed in light of the interest in the right to a speedy trial is designated to protect, number one, to prevent oppressive pretrial incarceration, and number two, to minimize anxiety and concern of the accused, number three, to limit the possibility the defense will be impaired. And the third of these is the most significant because a hindrance to adequate preparation of the defense skews the fairness to the entire system. And that's from Ridson, 154 Idaho at 251, if you want to look it up. So last part, it says defendant Vallow Daybell was served a warrant for arrest in this case on May 25th, 2021. Shortly thereafter, her case was stayed and she was transported to the custody of the Department of Health and Welfare for competency restoration efforts at a state hospital. While such custody has been deemed incarceration for purposes of awarding pretrial sentencing credit, the restrictions on liberty and access to activities were less stringent than what would have been enforced had defendant Vallow Daybell remained in the county jail. Further, as noted above, the length of this pretrial incarceration at the hospital was the defendant's request, and the commitment to a mental health facility was necessary to address competency and other mental health or medical concerns. Defendant Vallow Daybell's time in the county jail on this matter has been limited to approximately 1 month before her transfer to the state hospital and a few weeks since her return following restoration of legal competence. So essentially, what they're saying there is she had a nice little vacation at the mental hospital. It would have been tougher in jail. And it says, with regards to the second consideration, anxiety or concern of the accused, courts have noted that any criminal defendant will likely be stressed or anxious, particularly when facing serious charges, including murder. And let's just add death penalty to that, because I don't care how competent or out to lunch she is. That news, even though she knew it was coming, I bet hit her like a ton of bricks, as it should, considering the number of bodies and the way these people were murdered for nothing. But indeed, anxiety by itself is generally insufficient to support a claim of a speedy trial violation. Finally, this court must consider any hindrance or impairment to the defendant, Vallow Daybell's defense. There's been no assertion by the defendant of any impairment to her defense in relation to a delay of trial. In fact, there are multiple outstanding pretrial motions that have not been addressed. Co-counsel has been recently appointed, and discovery is yet to be completed. Certainly, the parties and the court would make extraordinary efforts to address all pretrial litigation, review extensive discovery, and prepare for the logistics of conducting a trial in another county in October. However, such efforts are likely to be at the cost of preparing an adequate defense, not to mention any other cases or defendants that may suffer delay as a result of limited attorney and judicial resources. Without an allegation from the defense that there would be impairment to Lori's defense from the limited delay suggested here, this factor must weigh against the defendant's asserted speedy trial right. Weighing the limited prejudice suffered by the defendant to this point, her assertion of speedy trial rights at arraignment against the relatively short length of the delay suggested here, and considering the complexity of the case and the valid reasons to delay the trial, this court can properly find good cause to continue the joint trial to the previously scheduled date beginning on January 9th of 2023. And then in closing, last thing they say, wherefore the state respectfully requests this court find good cause to continue the October trial date to the previously scheduled date of January 9th, 2023, and prevent any attempt for an improper severance of properly joined co-defendants for trial. So that is the filing. And I know it can get a little monotonous reading that, but it's important to see what they're using to argue to move her to January. And I think it makes total sense. She's not going to be ready by October. No way. And it's just better for everybody. The cost to the county, the witnesses having to testify twice. That can be risky, because if something kind of differs from the first trial into the second, it's going to be jumped on by the defense. I just feel like for the families, good grief, to have to sit through this twice. There's going to be tons of media attention. Hopefully the judge grants this, because I think they've made some very valid arguments that, it's not the state's fault that she was incompetent in a way since, May of last year. So we'll see what happens. I wasn't expecting this today. We all knew it was coming. I mean, Chad has it on the table. It's just it's the same set of evidence. It's the same charges, essentially, with the exception of the fraud charges for Lori doing the Social Security payments after the children were murdered. And obviously Chad cashing in that life insurance policy for Tammy after he murdered her. So yeah, guys, man, whoo, head spinning. It's like The Godfather. Just when I thought I was out, they pulled me back in. I was looking forward to bedtime at 8 o'clock, but here I am. But couldn't sleep on this, wanted to get it out. And one more thing to pull up real quick. There was a filing today by Lindsay Blake. It was response to request for discovery. It says, comes now, the state of Idaho, by and through the Fremont County Prosecuting Attorney's Office, notifies John Thomas that the discovery in the above referenced matter was provided to co-counsel Mr. Archibald on August 16th, 2021 and November 22nd of 2021. So what they're saying essentially is he's requested something. They're saying, hey, he's had it way before you came on. So that's the latest in this trial. And yeah, so I can't wait to tell you guys all about I said Comic-Con, CrimeCon. It was really great. Got to do the girls slumber episode with Hidden True Crime and Julie and Lori Hellis. Then did a live with Scott Reich, which was always fun. Had a great time. And yeah, so I want to talk about some of the things on the panel. I am rocking my body bags with Joseph Scott Morgan shirt he gave me. And him and his wife are just precious. He had an amazing panel with two podcasters that do the Piketon Massacre podcast. Very in-depth stuff about the Wagner Rodin case, which two trials coming up. That was super interesting. Can't wait to share with you some things they said. And anyways, all right, guys, we will see you tomorrow, and we'll see if anything else comes out. You never know. It's kind of like the case that keeps on giving right now after a lot of silence. So, all right, have a good night. We'll see you soon.